Hello, everyone. My name is Brian Earp. I'm the Associate Director of the Yale Hastings Program in Ethics and Health Policy, and also a Research Fellow at the University of Oxford. And I'm commenting today on a ruling that just came down from a U.S. District Judge named Bernard Friedman, who decided that the U.S. federal statute passed in 1996 prohibiting so-called female genital mutilation, or FGM, was unconstitutional. And people have been very confused about what the reasoning was behind this decision and what was motivating the judge to reach this conclusion. FGM sounds like the sort of thing that's really bad and you would want to have laws prohibiting it, so how could it be unconstitutional? I wanted to just explain what happened. This is one of the main areas I focus on in my own professional work. So I thought while all these swirling miscommunications are going on in the media, it might be helpful to have a sort of explainer laying out what the main issues are. So the first thing is that the judge makes clear that FGM is defined in such a way in the federal statute that it could be considered already illegal on the basis of just physical assault laws in all of the respective states. So it isn't the case that in virtue of this ruling, suddenly it's okay to just cut the genitals of girls without their consent and for medically unnecessary reasons. Now, interestingly, legal scholars for quite some time have been arguing that any time you cut the genitals of a child, male, female, or indeed intersex, and it's not medically necessary, this just is a form of physical assault, or on some statutes, a form of child abuse. Now, male circumcision doesn't tend to get treated that way because in the United States it's a common cultural practice that we're used to. But when you cut the genitals of a girl, the thought was that we should bolster the physical assault laws that already apply and come up with a new law that makes it clear that any form of cutting to female genitals done without consent under the age of 18 that is not necessary for the health of the person should be specially restricted. The problem is that this, according to the judge, went beyond Congress's authority to enact a statute because normally criminal proceedings are meant to be handled at the level of the state. So this is a sort of federalism issue where the judge said Congress didn't have the authority to make a law that applies to all 50 states because it would have to use something like the Interstate Commerce Clause. And the government couldn't prove in this case that the cutting was part of any sort of interstate market or anything like that. It was essentially a criminal act carried out by private actors at the state level. So the first thing to make clear is that by striking down the federal anti-FGM law as unconstitutional, this doesn't mean it's now permissible to perform female genital cutting if it's not medically necessary and it's done without consent. It already is a form of assault. Furthermore, 27 states have additional special laws prohibiting female genital cutting of this kind. So that's the first thing to get clear. The other issue is that when people think of female genital cutting, or FGM, as it's often described in this discourse, they have a sort of stereotype in their mind that it's this excision of the clitoris, essentially, and that this is done in the kind of popular imagination with a rusty razor blade in an African village somewhere. That's sort of the stereotype that most people have. What is uncommonly understood is that what the World Health Organization calls FGM refers to more than a dozen different practices that are carried out by different groups for different reasons with different tools in different settings. And in some countries, a third or more of cases have been medicalized. So just like male circumcision in the United States has been medicalized, it initially was a ritual practice that was introduced in the late 1800s to sort of combat masturbation. It then became part of the medical practice, and now it's an accepted cultural norm. In the same way, female genital cutting, or FGM, has been medicalized in many communities, and it's done in a hospital by doctors with sterile equipment. Now, in my own work, I suggest that that doesn't matter. It's still wrong to cut the genitals of a child without their consent, even if you do it in a sterile way, because you're wronging the child in virtue of violating their bodily integrity. Furthermore, female genital cutting falls on a spectrum of invasiveness. So some forms involve removing the external clitoral glands, the part of the clitoris that extends outside the body, but many forms do not. Some forms, such as the case that was being considered in this federal lawsuit, was a kind of cutting where a nick is made to the foreskin of the clitoris, basically of the clitoral hood. So in this case, tissue isn't removed. This practice is, in fact, far less invasive than male circumcision, and yet nevertheless it's prohibited. So the other thing that people are drawing attention to is a passage in the judge's ruling where the government argued that the federal law could be justified on the basis of non-discrimination requirements such that people can't be treated differently on the basis of race, religion, sex, or other characteristics. And the judge struck down this reasoning by saying that if you have a law that specifically prohibits the cutting of girls' genitals, then this cannot logically further a non-discrimination act on the basis of sex, because the reasoning here is that it's a sex-specific law. So the only way you could get around this equal protection issue is if you had a law that did not specify that the only kind of cutting that you're not allowed to do is to girls. You would have to have a law that says any child, regardless of their sex or gender, including intersex children, cannot have their genitals cut if it's not necessary for their medical needs. So those are the issues I wanted to put on the table. I'll put some links to some essays that get into the legal and ethical details quite a bit more intensely. And I'll also just sort of proceed into a talk I gave last month in Birmingham, England, which was exactly on this case, the federal case. And I sort of predicted that given current inconsistencies in the law, in the way that genital cutting is treated for minors, something like this was going to have to happen, where the law was unsustainable. And what I argue then is that advocates for children's rights should band together, and rather than making this an issue about sex and gender, they should make it an issue about protecting a child's right to bodily integrity. And going forward, that will be the strongest legal argument that won't be vulnerable to equal protection considerations or non-discrimination considerations. There may still be concerns about whether you could have a federal law of this kind, because you would still have to have some reason why it shouldn't just be handled at the state level. So that will still be a matter that's contested going forward. But even the state laws will face problems if they are drawn along the lines of sex or gender, as I argue in the talk you're about to see. So thank you for your time and attention, and I hope that clarifies some of the issues.